Good afternoon, everybody, and thanks so much for joining us today. Welcome to Fraser Jones' first Irish employment legislation webinar. My name is Claire Smith. Sorry, my name is Claire Schindler these days, and I'm the Regional Director for Ireland here at Fraser Jones. We're a global HR executive search and recruitment consultancy. So we place exceptional HR professionals within businesses, from startups and SMEs to global FTSE organisations, and we work both within the permanent and interim sector. I lead the Irish business and have significant local knowledge with 25 years in the recruitment industry. Fraser Jones have global reach. We have offices across the UK and Europe, the US, Asia, Middle East, and Australia. So we're uniquely placed to support global organizations with all of their HR talent requirements. And as HR professionals, you all know the pace of employment law does not stand still, and there are changes and updates coming down the line all the time. So today's speaker, Hilary O'Connor, is here to review and demystify key employment legislation changes going into 2024. I did talk to a number of you guys over the last couple of months to gain a sense of the topics that were most relevant to you, and Hilary has kindly taken these on board, along with other key areas of focus. I'm very pleased to welcome Hilary O'Connor today. Hilary is a solicitor and a legal consultant. You may be familiar with her from her series of straight-talking legal advice posts and reels on Instagram. Hilary is a highly accomplished legal professional with a keen interest and significant experience in employment law. She's qualified over 18 years ago and has recently been elected to the Law Society Council in Ireland. So a little housekeeping before I pass you over to Hilary. If you have any questions throughout today's session, please add them to the Q&A box. If there are questions we don't get to, we will attempt to answer them separately afterwards and send out an update to you all. So without further ado, welcome to Hilary, and I hope you all enjoy the session.
Thank you, Claire, and welcome everybody. I am delighted, of course, to be here and to join you and to give you the updates in employment law for the last year and what I think is going to be, I suppose, relevant and current coming into 2024. There is lots to talk about, so I won't delay and I will share my screen now and we will get started. Okay, so we're going to go through remote working, and so the Work-Life Balance and Miscellaneous Provisions Act brought in a lot of changes. It came in April 2023. There are lots of different sections in this: remote working, flexible working, and other areas. Although we said we'd concentrate on remote working and flexible working, Claire, I have included others which have come into force since. So there is a lot of slides here. So I'm just going to run through remote working. So this is under section 20. So as we know, there's no right to work from home unless set out in your contract. The COVID pandemic, as we know, changed everything, and work we'd worked from home and successfully. So, of course, there was much lobbying and pressure on the government. And here we go. And this created, I suppose, as the backdrop to the Work-Life Balance Miscellaneous Provisions Act, which was signed in April 2023. Interestingly, a recent survey, there was 44% of employees said they would leave their job if remote working was possible, even if this meant taking a pay cut. Now, I would encourage you to read that again because it is a very, very interesting statistic. So this is why remote working is important and it is here to stay. So, the qualifications for remote working. So you must be in continuous employment for 6 months. The request must be in writing and signed by the employee and specify the proposed arrangement. They must refer to the code of practice, of course, which is not out yet. The WRC have to do this, and the arrangement must specify the commencement, when it's going to commence and when it's going to expire, if applicable, and specify the reasons for requesting this. The location, of course, has to be specified, and you must give the employer 8 weeks' notice of when this is going to kick in. So the employer's obligation then is they have to consider it. They have to have regard to their own business needs. They must respond within 4 weeks, and it can be extended to 8 weeks. If it's approved, they will sign this agreement, which sets out the details of it, and they'll put in a commencement date. And if they refuse, again, you have to advise the employee of reasons for the refusal. So if the arrangement is having an adverse effect on the employer's business, it may be terminated by notice in writing. The employee may respond within 7 days of this notice, and the employee returns to the original place of employment. So that's, I mean, it's obvious, but these are the little things to remember. The right to request a return, of course, if an employee is not happy with the arrangement, they can request to return to their place of employment, the original place of employment, and they can do that in writing and give the employer notice of this, and the employer must consider it again within 4 weeks and approve and agree a return date. Or if the employer doesn't want the employee back, they can refuse and give reasons. So if there's an abuse of remote working, an employee is not discharging all their duties under the contract or the agreement, then the employer can give notice and say this arrangement is being terminated. The employee then can respond, and the employee will then return to the original place of work. So the employee is protected from penalisation. So an employer obviously may not penalise an employee for exercising the right to request this. So penalisation includes dismissal, suspension, demotion, or a threat of that. The transfer of duties, less pay, reprimand, intimidation, they're all examples, again, of penalisation, and an employer cannot do that. So these are the important considerations for an employer. Where is this remote working going to take place? Is it going to be a hub? Is it going to be at home? If it's going to be at home, what are there connectivity concerns? If it's at home, you need to consider providing a safe place of work, which would include the workstation, the desk, the chair, the usuals. The considerations under the Safety, Health and Welfare at Work Act, this is important, and these are continuing, although this place of work is not your office anymore, or it is now somewhere else. The Organisation of Working Time Act, again, you need to consider this and the right to disconnect. Insurance, any insurance issues, public liability, employers' liability, and GDPR considerations. This is huge, and you need to have policies to consider to figure this out. This remote working, how that is going to work, what information the employee will have, and are there scanners? What is available to the employee? So you'll have to have a policy, a remote working policy. Employers will now have to have this and think it through. I have said this is the early days, and it is the early days of this legislation, but you will revise your policy, I think, on an annual basis after a trial and error, really, as to see how it is going ahead and how it is going for everybody. You should think also about the type of employment you are in, and you should specify the kind of jobs that are just not suitable for remote working. So moving on, this is the right to request flexible work for caring purposes. This is in section 13B. So again, you must have 6 months service. This is to care for a child who's under 12 or 16 if they are under a disability, and or a spouse, cohabitant, or anybody who's living with you. It's parent, sibling, grandparent, so person that you live with. You must give 8 weeks notice in writing of the proposed arrangement, and the employer must respond within 4 weeks and may request additional information. So this can be reversed if there's an adverse effect on the business. Of course, it's probably very obvious, but I mean, an employer is there to run a business, and these are all accommodations that if they work, they great, but if not, the employer has the right to reverse this. The flexible work includes flexible working schedules, and that can be around the working at the hours or remote working requests. So again, we are awaiting a code of practice from the WRC Now, it is thought that this will be operational from the end of the year, but as of date, it isn't it isn't operational. This it has come into effect, and it's under this Work-Life Balance and Miscellaneous Provisions Act. The breastfeeding breaks under Section 34, so it is up to 1 hour a day for full-time staff, and it's pro rata for part-time. This can be 1 hour, 2 30-minute breaks, or 3 20 minutes as agreed. It is paid by the employer, and it is now until the baby is 2 years of age. This was previously 6 months. So this is in line with the positive breastfeeding movement that is going on. So that's a positive, but another thing that employers have to consider. So moving on. This is under this Work-Life Balance Act. As I said, there's lots of there's lots of new things in this act. So this is leave for medical care purposes. So this is a 5 days unpaid in a 12-month period. This is leave in order to care for a child, a spouse, cohabitant, parent, sibling in need of significant care or support for a serious medical reason because of illness, injury, or disability. So they are the requirements: significant care for a serious medical reason. So the employee will have to produce a medical certificate. So inform the employer in writing as soon as possible. And this leave, this 5 days in the 12-month period, is in addition to carers leave and force majeure. So it's a further consideration for employers, and one they should be aware of. This has come into effect. So this act, there are parts of it that have commenced in July and parts of it that have commenced in November, and there are also parts that haven't commenced yet. This has commenced. So, and this here, again, under that same act, the domestic violence leave, this is under Section 7, and this came in actually on Monday. So this is 5 days paid leave in the 12-month period, paid by the employer. This is to facilitate an employee or relevant person to seek medical help, counselling, go to the guards, emergency accommodation, or just accommodation for on a more permanent basis, to seek help through women's aid or men's aid, or to obtain a court order. So that's for the purpose. It's the relevant person is a spouse, cohabitant, child, civil partner, dependent. So the employee can help either of those people set out there. So it isn't that the employee has to be one of those people. They can also be helping those. There's a daily rate. So it's 5 days paid. There is a daily rate. We are awaiting that daily rate at the minute. So I don't have that for you yet because it hasn't come out. There is no service requirement for the employee to avail of this. Of course, we can probably understand the reason. It would seem to be against policy if there was a service requirement for an employee. But nonetheless, it is a significant leave and a significant entitlement for an employee who finds themselves victims of domestic violence, or the relevant person is a victim. So it's one, again, employers need to be aware of, and it is operational as of last Monday. Now, so that finishes the Work-Life Balance Act. There is lots in that piece of legislation. It's a very important act, and as I've just taken you through very quickly, I would encourage people to familiarise yourselves with the provisions of this act. The slides there have set out in great detail what is required for the employees. And so it is a good aid memoir for you. So moving on to probation and probationary periods. So we had this European Union transparent and predictable working conditions regulations in 2022. So these change things for probation and probationary periods. And um, probation is a really it's normal practice, of course, now for testing out an employee. You have to see if they're suitable for the job, and they're a really good and cost effective way of checking out the suitability of an employee. They should be better used, in my view, but um, so we are used to probationary periods. What has happened with these regulations is that they've introduced new statutory requirements, which sets out that private sector employees, the maximum of the probationary periods is 6 months, and for public sector, it's 12 months. And then fixed term contracts and specific term contract, or specific purpose contract, that should be it's proportionate, taking into account the purpose of the contract. And then, of course, successive fixed term. So if you have if you're contracted for 1 year, and so you have 6 months probationary leave, and you're then get another contract for another year doing the very same job, it wouldn't be fair to put you on another probationary period for 6 months. So you've the one probationary period will do you for that contract. So the probationary periods for private sector employees may be extended in exceptional circumstances up to a maximum of 12 months. And it goes further, and it says it's for the benefit of the employee. So it would be, I suppose, so the employee can demonstrate that they are the right person for the job. So the duration of probationary period can be extended if the employee avails of maternity leave, parental leave, adopted leave, and carers leave, sick leave. So they are all specifically mentioned in the regulations. So you can, of course, extend it for those reasons. As I said, probationary is a very cost effective way of dealing with underperforming employees, or for testing if that employee is right for your company. So you should engage with the employee and give them feedback and opportunity. And I'm regularly consulted with by employers who in month 5 engage with their employee, and I really discourage that. If probationary, you should monitor that employee as much as you can throughout that 6 months, and not just kind of go in month 5 and saying, Jesus, what are they like? You should really, really know what they're like up to well at that stage. So I think for completeness, it's good to talk about dismissal during probationary period. And of course, the relevant legislation here is you have the dismissal under the Industrial Relations Act, the dismissal under Unfair Dismissals Act, dismissal under Employment Acts, and wrongful dismissal. This is so just normally in probationary period, you have a shorter notice period. It's normally just 1 week, okay? And so if you have employed somebody who hasn't reached the 1 year threshold, the remedy for the employee is under the Industrial Relations Act. So where the emphasis is on fairness, natural justice, but the outcome is not binding on the parties. But what is important for employers is that there could be huge negative publicity about an unfair dismissal here. So you do need to be mindful of fairness and natural justice. Then in dismissal under the Unfair Dismissal Act, of course, normally you have to have 1 year service, but you don't if you are dismissed for the membership of a trade union, if it's pregnancy related, or you're exercising protected leave and a protected disclosure. So also dismissal under the Employment Equality Acts. There's the 9 grounds, the usual grounds, for discrimination, and if there is dismissal, um, there you don't have to have the service requirement. So you have wrongful dismissal, then this is through the courts, and you do hear about injunctions, people taking injunctions to stop a dismissal. Then dismissal for poor or underperformance, that seems to be the way a lot of employers go if there is dismissal under in the probationary period. The contract normally states suspension of disciplinary procedures, so your normal disciplinary procedures. So and the contract will normally say during the probationary periods you can be dismissed for no reason, which is the preferred route. So these are two injunction cases here, and the court, basically this went to the Court of Appeal, this case, the O'Donovan case, and here they tried to get the courts to infer that there should be fair procedures for performance, but the courts actually come out and says dismissal for misconduct must afford fair procedures, but not for poor performance or where the contract expressly allows for termination for no reason. So that is the law as of and then similarly in Buttimer, where the employer can dismiss for no reason or poor performance without any obligation to provide fair procedures, but for misconduct, then the obligation is to adhere to fair procedures. So employers need to be cognizant of the reasons they are giving for the dismissal during the probationary periods, and you need to be mindful. So you also need to be mindful of your engagement with the employee during probationary periods. Again, month 5 and 2 weeks, heading on to meeting with the employee. It's nearly too late to engage with them. But so you should know at that stage is that if that employee is right for you. So that's probationary period. Moving on to sick pay, which I think everybody is used to now at this stage. So this was the Sick Leave Act in 2022, and it commenced in January. So what does it provide? It gives 3 statutory sick days in 2023, 5 2024, 7 in 2025, and up to 10 or 10 in 2026. So we're it's an incremental into the pay for workers, and of course much lobbying and much input from all stakeholders on this. So the entitlement is 70% of the workers' pay to a maximum of €110 per day. To qualify, you must be employed for 13 weeks. It applies to full and part-time workers and agency workers. The employee is due to work but can't work because they're ill. So importantly, they must provide the certificate from the doctor. Now, I know from my own social media, that is a real bugbear for our employees. And I'm always interested in questions when I put up information, because people say, well, sure, it costs me 60 quid to go to the doctor. Like, why would I be bothering? And that it really isn't a benefit. And I'm always interested in those questions, because I think, look, we're trying to strike a balance here between, encouraging almost absenteeism and given extra 3 days sick, or given 3 days holidays, as somebody says. And some of my questions are, if I don't take the sick days, do I get the 3 days holidays? And I'm always interested in those questions. So that's sick pay. We've had one decision as a result of the sick pay and the differences between the entitlements under the Act and an employer's sick pay scheme, and that decision was this decision here, Katrina Les Linzinska. Of course, I haven't done her any justice in pronunciation there, and Musgraves. So here, she was out sick for 4 days. The respondent sick pay said there's 3 waiting days to discourage short-term absence. The claimant's case was she was due the first 3 days under the Act. The respondent argued the Act did not apply where the scheme was more favourable overall. And then here, the adjudication officer, he weighed up the benefits of this scheme and the Act, and went on to decide, it's my view that the duration of the paid sick leave in the employer's scheme, the amount of the sick pay, the 26 service requirement, and the 3-day waiting period combined to provide benefits that, on the whole, are more favourable to the employees than the benefits provided under the Act. So the adjudicating officer decided here that Section 9(1) of the Sick Leave Act, the company was exempt. So this has been the only case decided so far. So there's much to see, and it'll be on a case-by-case basis. But I think it's fair to assume that you will be weighing up and looking at the qualification, the length of a sick pay scheme, and that's what an adjudicating officer will look at. So here we go. So again, an employer can apply for an exemption for between 3 months and a year if the business is experiencing severe financial difficulty. It's best if the employer has agreement from the employees about this, but it's not essential, and the Labour Court will keep a record of these decisions, and you can appeal on a point of law only to the High Court. So that's the Sick Pay Act. So what am I telling you to do? I think you should revise sick pay policy, taking into account these provisions, extend probationary period as appropriate to take sick leave into account, and you're required to keep records up to 4 years, including details of the employee's duration and instances of sick leave, the rate of pay for each employee, and who availed of the scheme. So it's a bit laborious, but if you don't, there's a £2,500 fine that you don't need to be paying. So you can't, of course, penalise employees for exercising the rights to statutory sick pay or sick leave. So employees, if they're unsatisfied, can make an application to the WRC, and 4 weeks compensation is potentially what they can get, an appeal to the Labour Court. Okay, so that's that. So now we did say, Claire, when we were going on with the topics, we had talked about long-term illness and mainly terminal illness and miscarriage. I haven't kind of fully covered it here, but I will mention it. So sick leave, long-term illness. So under Section 6 of the Unfair Dismissals Act, a dismissal is fair if it's for one of the following reasons, one or more, right? So you can dismiss somebody on the grounds of capability, competency, conduct, qualifications, illegal behaviour, redundancy, or the expiry of a fixed term contract or a specific purpose contract. So for the purposes of sick leave, we'll talk about the ground of capability. And then I have said here, an employer should have disciplinary procedures, or for these purposes, it's better called capability procedures. Disciplinary does seem rather adversarial. So capability procedures for dealing with the issue of sick leave. So you should have a policy and procedures, and you will deal with things differently depending on whether it is short or long-term sickness. These procedures should explain what's expected of an employee and what's expected of the employer in these circumstances. The procedures should have a tiered application of sanctions. So you move from the verbal warning to the first written warning, the final warning, and ultimately dismissal. So For short-term illness or persistent absenteeism, it should be distinguished from the more serious nature, obviously, of long-term illness, where the employee is out of work due to long-term or terminal illness. Okay. Um, so where did I go? So then, so persistent absenteeism should be dealt with by meeting with the employee as per your policy, set out the absenteeism, request an explanation, send them to your doctor as appropriate, and present this report. And they may present their own report, hear the feedback from the employee's doctor, and issue a sanction. It's wise to begin with a verbal warning first and then advise always the employee of their right to an appeal and repeat as appropriate. Um, for long-term illness, it is, of course, it varies depending on the illness. And, I'd advise people to be sensible about these things. And so the long-term illness, review employee's absence due to the illness, request a report, meet with the employee, discuss the report, and advise of the decision. And and the most important thing I think there is don't be so quick to make a decision, um, especially when you're dealing with long-term illness or terminal illness or an illness that you're in the middle of treatment for the illness, and there is optimism that the employee can get back to work. So um, compassion can go a long way in these instances, and so time in which to act will vary depending on the nature of the illness and the reports available. Get this wrong and you're looking at discriminatory dismissal on the grounds of disability, which is a punitive award where the employee does not have to mitigate their loss. Proceed with caution, and I can't put that in big enough writing. And 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 beyond the discriminatory dismissal, the negative publicity from that could be huge and so damaging. And I know myself from practice that I've had an astonishing amount of questions around where an employee was dismissed when they said they had a diagnosis of cancer, and where they were shocked about this, but um, they had a different fight on their hands. So a lot of times they were out of time to do something, but I was just shocked that um, I can only think that an employer that would do that is an employer that hasn't gone and asked for advice on it. So with regard to the miscarriage, again, similarly, I've had questions in where an employee was dismissed for being out due to miscarriage. And of course, that is unfair and horrendous and all of that. So the negative publicity around something like that, rightly so, in my view, but that is not a long-term illness, and or it can, but um, I just can't see the circumstances where you would go to dismissal and in those. But I can only assume that these are employers that have chosen not to get advice. But at their peril is what I would say there. So moving on to the joyous topic on a Friday, the 1st of December of the menopause. Delighted to be able to talk about this. So this covers, and this is our final topic. You'd be delighted to hear. I save the best to last. Menopause covers perimenopause, menopause, postmenopause, and can start for women as early as their 30s, but generally starts in their mid 40s. It covers these symptoms, which are probably too small for you to see. But don't worry, I will let you know what they are. These symptoms, I don't want to gloss over them. Hot flushes, difficulty sleeping, palpitations, headaches, migraines, muscle aches, joint pains, changed body shape, weight gain, skin changes, reduced sex drive, vaginal dryness, recurrent urinary tract infections. Oh my God. Um, Tammy Wynette, she lied when she said sometimes it's hard to be a woman. It's always hard being a woman, but anyway, this is what the menopause looks like, and it's pretty horrendous, isn't it? So these are the facts, right? It can last between 3 and 14 years. These were traditionally women issues. They're taboo, and like, who wants to be talking about this? And jeepers, he's still going on about it, and that's the kind of attitude we've had. But it has now changed, and we've moved from this being a taboo subject to a place of empowerment regarding these issues. This has been undoubtedly helped by social media and media. Davina McCall had a very successful sex, myths, and menopause program last year or the year before in the UK and in Ireland, would you believe? 2.5 weeks of live line Talk to Joe was dedicated to the menopause. I mean, Joe Duffy educated the women of Ireland about the menopause. Who would have thought it? This happened. So this kind of created, I think, an awareness and almost a revolution for women to kind of go, Jesus, yeah, this is a thing and this is happening. But it raised awareness for women, and these women live and work with us. And so we have an awareness month, which is in October, and a World Menopause Day, the 18th of October. So this is going to get even bigger, and it's going to become more and more relevant. And like, what is it to do with work? Like, why am I going on about this? Everything. That's what it has to do with work. We are in the workforce. People who are suffering with the menopause are in the workforce. This is our census information here. There's 60,000 more females in the state. So more women are at work than ever. You're suffering these symptoms while working. Menopause can be up to 50% of a woman's working life. So, oh joy. So what can an employer do? So like, very, very, I think small steps here will have a huge impact. I can't emphasize that enough, actually. So, an employer needs to be reminded of their obligations under employment equality legislation, in particular grounds here are gender, age, and perhaps disability. But an employer should be proactive with regard to awareness and education. And I've actually seen some menopause policies. I'm thrilled to see them. And I'm also, I had a conversation with an employer of a big company, 50 people, and she was talking to me about a potential disciplinary issue with her employee. And she mentioned to me, she says, now I know this lady has had a particularly difficult menopause. And I thought that was incredible for her to say to me. So this is coming into the workplace. It's here and it's here to stay. So to see policies, it really does give a great message to your employees. And education is incredible. And even just to be empowering people to talk about it. I mean, that's just brilliant. So, so an employer can avail of the manning training and opportunities for their employees. Employees will appreciate that, and for people who are the managers, the line managers, all the way up, to actually educate them, and to remove this from being an issue that nobody wants to talk about and, like, put away in a corner. So it could be as simple as turning down the air conditioning, or turning down the heating, or turning up the air conditioning, or sitting, or letting somebody sit near a window, more understanding around toilet breaks. Um, and but education and training is really at the heart of this, and I do think that you will, as an employer, you'll reap the reward of this. So I think it's only starting. The menopause conversation is going to get louder, and you'd be delighted to know I've rattled through that as quick as I could. Um, so that's the end of it. That's the end of the chat for me. So
Thanks, Hilary. We
if
have
there
a
are
few
any,
questions, Hilary. That was great. So Laura Lawless wanted to know if there's any issue with potentially sharing a cohabitants medical cert with your employer from a GDPR perspective, regarding leave for medical care purposes.
well, I suppose it is the person that is, so if you're a cohabitant, your spouse or whatever, needs your care, the employer needs to know that this is a legitimate situation. So I'm sure the cohabitant or your spouse wants you to be able to provide this care, so they will give you the consent
Permission.
for.
Yeah.
Yeah, so I think that'll be, I mean, we have to be sensible about things. The employer is entitled to look for these proofs. So I mean, does the employer need to get does the employer need to get the consent of the employee, of the cohabitant? I don't think so.
Okay. And then Tressa had asked, how is medical care purposes different from force majeure besides the time frame?
Because force majeure generally is an emergency situation. This is for medical care. So it is in addition to it. It is not, force majeure is generally emergency situations.
Out of your control.
Yeah.
Yeah. Okay. Tressa had asked also, can you extend probation past 6 months in a private company if you're transparent that it's due to concerns about their suitability for the role, rather than dismissal to give them additional time to turn things around?
Yes, you can. And the way it has been set out is that they have said that it's in the employee's best interest. And of course, it is in the employee's best interest if they get to keep their job, So I think you can. So, but it can't go beyond 12 months. So yeah, you can, but it's an exceptional circumstances.
Okay, no problems. Shona had asked if she has a new joiner who joins partway through the financial year, does she prorata the amount of paid sick leave someone can avail of, like you would with annual leave, or how does it work?
No, it's 3 days in that year. So
Even if they were there a month?
even if they were a month. Oh God, do you know what? I'm not 100% on that.
We might double check on that.
Yeah, that's an interesting one actually.
Yeah.
With all the questions that I've got on sick leave, that I've never got one. I've never got that one. So I will check that out and I'll come back to you. But I think
Okay.
you are obliged, to be honest with you. I would say you have to pay it.
Okay. If you have a persistent absenteeism during probationary period, what grounds do we have for termination of probationary period? Would it be capability and performance, or how would you proceed forward?
Well, I would, your probationary period, your contract, it should say, we can terminate the agreement for no reason at all. Now, if you wanted to extend the probationary period because of the absenteeism, fine. Otherwise, you can just say, this hasn't worked out and we're terminating your employment.
Okay.
I think where these injunctive cases certainly, where employers are getting into trouble, is that they're going down a misconduct route, or they're pulling employees up for poor performance, and they are muddying the waters there. I think if you keep it as clean as you can, if somebody's persistent absenteeism, like, an employer will know if this is trouble. If they showed promise then, and you want to give them the benefit and extend the probationary period because they've been out sick for a month, because they got some sickness or whatever, fine. But other than that, I think you need to just treat that period as it's a cost effective way of getting rid of somebody that isn't suitable for your company, and don't muddy the waters.
Okay. Have you this is from Laura Lawless, any recommendations on reliable resources if writing a menopause policy?
Well, I did see a really good one there during the week. So I think where you start with for a menopause policy is you start with by recognizing it, and again setting out these symptoms. what they are. And that says, okay, geez, the employer knows what it is. And I think you can start, and again, it's so different for every employer, because a small employer of like 5 people and an employer of 500 people, it's different needs, right? But and what is your job? What do you do? So what is your work environment like? What is it like temperature wise? Is it possible somebody could sit beside the window, for example? Is it possible to change things? Or are you talking about production line? And if it is production line, then you're talking about, so I would be very clear in that you are committed to providing training, and especially for, say, the line managers along the production line, to train them that women may need extended breaks or may need more toilet breaks because of menopause and things like that.
Yeah.
That's where you really have to see the type of workplace you are, then see what your workplace looks like, what's your job, and who is in there. So
Yeah.
and step it up along the way. But I mean, I think your policy should start off by saying, yeah, I know it's a thing, and then you can build on it.
Yeah.
I really do think it's a powerful message to give to employees by actually having a policy. And like, but I don't think the expectation is to spend a load of money on this either. But I just think education and providing training. And you know what? There's so much, especially bigger employers, there's so much available to employees anyway. The counselling, the employment assistance schemes, um, because a lot of people didn't even realize that they were perimenopause, or perimenopause was a thing.
Yeah.
Information is key, training, like that's fairly low cost,
Yeah.
would be my view,
Okay. Lola asked, can you sue an employer for terminating an employee's probation without notice and without providing necessary support to the employee?
Can you sue an employer? You can always sue an employer. Can you sue an employer for terminating without notice? So
Without
termination without notice.
probation, without notice, and without providing the necessary support while they were an employee.
Yeah, but you see, I suppose that has a journey, and for the employee to be successful in that claim, okay, you have to show that you were looking for the support and you weren't provided that support, and then you can sue them. But what are you suing them? You're suing them under the Industrial Relations Act, probably, unless you are going to sue them because you were pregnant or because they discriminated you under the Employment Equality Act. So you're suing them really under the Industrial Relations Act, and a finding there is not binding on the employer. So it kind of doesn't matter unless you are, a semi-state body. It is persuasive, and unless it's going to be very negative publicity about it. So the employer is protected, but the employee would have to show all of these things. I was looking for support. I was doing all of this. And like generally they probably wouldn't have that.
Yeah. Mark has asked, can a company top up sick pay if the day rate is above the statutory requirement?
I was mid cough there, Claire.
Sorry.
Apologies. So I asked, can they top up? Can you top up?
Can you top up sick pay if the day rate is above the stat requirement?
So yeah, you can top it up. Like as in the employer give the employee more.
Yeah.
Yes, and this is where the great debate will be, as more and more of these cases go through the workplace relations commission. Like which are you're not opting in, which is more favorable. So yeah, you can top up all you like.
Okay.
That's
okay. If statutory sick pay is 3 days in a year, is the year classified as January to December as opposed to over a 12-month period?
Yeah, it's January to December. Yeah.
Okay. And then would you recommend a women's health policy to incorporate menstrual health, menopause, pregnancy support, etc., that everything is kind of in the one policy?
Yeah, but generally, there probably is maternity around that space. There are those policies anyway, so
Yeah.
this can be an extension of it.
Yeah.
But yeah, it would be no harm to just to have that whole space together.
Yeah, I think it kind of aligns, doesn't it, with everything else. I did miss one. Sorry, we did have a significant number of questions. Let me see. No, I can't find that last one. It was something to do with industrial relations. Hilary, a lot of people have requested throughout the webinar if they could receive your slides.
Oh, absolutely. There is so much information on them, and I was kind of flying through it, but I am a nerd for information. I much prefer if the information is there in front of me rather than as a reference point. So that's why some of the slides are a bit
wordy.
Jeepers, there's so much, they're a bit wordy. Wordy is a new word, I think. It's theme of the day. And but I kind of prefer that rather than have to just go to multiple locations for information.
I know what you mean.
Yeah, absolutely. Yeah.
Okay, brilliant. So look, I think, huge thank you. You covered so much there, Hilary, today, and really, really appreciate your time and to take the time to actually be with us today. It was really informative. And I hope everybody got something from it. Thank you so much to everybody who joined us today. So what I'll do is I will formulate a bit of a pack for everybody. I think I'll send maybe some feedback forms to everybody who attended to get a sense of what you found useful in the session, the topics or areas of interest that you'd like us to include maybe in our series in 2024. And then I'll also, as I say, I'll share the slide deck from today with everyone so you can review at your leisure. What we'll do then is we'll also send you Hilary's contact details. You can connect with her on LinkedIn and obviously, watch some of her amazing reels that she has up on Instagram, which are so informative and actually quite, really interesting. And we'll get Hilary's contact details to you, as I say, her direct contact details. And I think that's it. And for the first time ever, I think we've covered everything and we're finishing on time.
Oh yeah, delighted. 1st of December. Yeah, because there's nothing worse being on those webinars that just go on and on.
I know.
So I have sympathy for people, but I do think there's a lot going on. It is interesting times. The remote working, flexible working stuff, it's a bit of a head wreck at the moment, but it is going to be live, I think, pretty soon. So that's why there's a lot of information on all of that. So look, I'm delighted to have been here, Claire, and thanks so much for having me. And it's the 1st of December, so let's get the Christmas trees up and all that stuff. So.
Thanks, everybody. I hope you all have a lovely weekend, and thanks so much for joining us. I hope you'll join us again for our next one. Thanks a million. Bye. Okay.